Today, a constitutional boundary that has defined American gun rights for a century has finally collapsed. This is not a partial victory, it is a legal earthquake. The Supreme Court has just issued an emergency order that, effective immediately, declares the entire concept of subjective, permission based firearm carry permits to be constitutionally void. Even more stunning, the Department of Justice quietly but decisively supported this unprecedented shift. The message sent from the highest court is now crystal clear. The right to bear arms is not a privilege subject to government paperwork, subjective approval, or arbitrary fees. It is a fundamental right that precedes any state bureaucracy. This is the moment where the Second Amendment, the right of the people, reclaims its authority from the state. We are going to break down the full legal ramifications, the DOJ's seismic shift, and most importantly, what this now means for the next critical cases waiting for the court, including the long-anticipated AR-15 ban Supreme Court challenge. Pay close attention. For generations, the right to self-defense was held captive by an administrative wall. States, particularly those operating under may-issue systems, forced law-abiding citizens to beg, prove, and pay for the right to carry a firearm. The requirements imposed fees, demanded subjective good cause justifications, and created intentional bureaucratic delays designed to crush the exercise of a constitutional freedom. That era has officially ended. The Supreme Court's emergency order, rooted in the foundational principle of the Bruin decision, unequivocally states that a right which shall not be infringed cannot depend on permission slips. The ruling reiterates the Bruin standard. When examining a firearm regulation, the government must prove the regulation aligns with the historical tradition of firearm regulation in this country. Simply put, if you cannot find a historical analog for a subjective permitting requirement, that requirement is unconstitutional. The court's action cuts the legs out from under every discretionary permit system in the nation. It transforms those last remaining may-issue jurisdictions, states like California, New York, and Illinois, from being the gatekeepers of a privilege to being the subjects of immediate and decisive legal challenge. This is not just a strong ruling, it is the ultimate affirmation that the Second Amendment Supreme Court precedent is real, it is enforceable, and it is now the law of the land. Constitutional carry has been given a national legal backbone. Perhaps the most shocking element of this development is the position of the Department of Justice. For decades, the DOJ has stood as the primary defender of incremental gun control and state regulatory power. They have consistently fought against the expansion of the individual right to bear arms. But in this case, the DOJ did not fight. They quietly, formally, signaled their non-opposition to the court's action and reasoning. Internal assessments and legal filings reveal that federal attorneys finally recognized the unsustainability of defending these subjective permit systems after the court delivered the Bruin decision. The legal terrain had shifted too dramatically. To continue defending arbitrary licensing delays, excessive application fees, and vague character judgments would have been a guaranteed, costly, and embarrassing legal defeat. The DOJ's acknowledgement of the permit system's legal fragility is a profound capitulation. When the chief law enforcement arm of the federal government steps aside and allows the total collapse of a core component of state-level gun control policy, it signals a deeper acceptance that the Heller clarification and the Bruin framework are now the unchallenged constitutional reality. This is a monumental shift in government behavior, effectively green-lighting the era of permitless constitutional carry nationwide. To truly understand the weight of this ruling, we must anchor back to the three landmark cases that made it possible. It began with District of Columbia versus Heller in 2008, which recognized the individual right to keep and bear arms for self-defense. Then came McDonald versus Chicago in 2010, which incorporated that right against the states. But the final hammer was New York State Rifle and Pistol Association versus Bruin in 2022. Bruin did more than strike down New York's May issue system. It established the text, history, and tradition test as the singular legal standard for evaluating all modern 2A news and gun regulations. This emergency permit order is merely the logical, necessary extension of that rule. The court is simply saying if you cannot prove that a regulation has a verifiable historical analog, a parallel restriction dating back to the founding era, it is gone. This framework is why the permit wall crumbled. States could not find a historical tradition of forcing law-abiding citizens to obtain permission slips to exercise a pre-existing constitutional right. The age of judicial compromise, where courts attempted to balance the Second Amendment against perceived public safety concerns, is over. The right is not subject to a balancing test. It is protected by history and now by an assertive Supreme Court. The collapse of the subjective permit system is an overwhelming victory, but it is not the end of the fight. It is merely the clearing of the battlefield for the next, even more critical, constitutional confrontation. The very legal standard that just voided carry permits is now ready to be applied to the next frontier of gun control: the outright ban of common firearms and magazines. The legal community, pro-Second Amendment organizations, and those who follow Supreme Court gun case news are now fixated on the next cases waiting at the Supreme Court's doorstep: Vermont v. Cook County and Duncan v. Bonta. These cases deal with outright bans, not restrictions on carrying, but bans on possessing the most popular, common, and effective self-defense tools in America. As we know from previous denials, Justice Kavanaugh himself has already indicated that the court will need to take up a major rifle ban case very soon. The permit ruling has only increased the urgency and the constitutional necessity for the court to take action on these bans, which have been allowed to stand by defiant lower courts who refuse to apply Bruin correctly. The question is no longer if the court will rule on these bans, but when and how decisively. Let's zero in on the primary rifle ban challenge: Vermont v. Cook County. This case challenges a Cook County ordinance, which is now largely overlapped by the statewide Illinois PICA law that bans the sale, transfer, and possession of what they call assault weapons, including the widely owned AR-15 platform. The county's ordinance, like the Illinois PICA law, bans hundreds of rifles by name and then bans others by defining characteristics like pistol grips and folding stocks. The core argument being advanced by the petitioners, supported by the history-based ruling on the permit systems, is simple. The AR-15 platform is in common use for lawful purposes, and therefore it is protected under the Second Amendment Supreme Court precedent. Millions of these rifles are owned by law-abiding Americans for home defense, target shooting, and competition. If a firearm that is demonstrably in common use is declared illegal, then the entire Heller and Bruin framework is meaningless. The problem, which the Supreme Court must address, lies in the deeply flawed reasoning of the Seventh Circuit gun ruling in a case called Bees. The Seventh Circuit and the lower courts in the Cook County rifle ban challenge ruled that AR-15s were too militaristic to be protected arms, equating them with M16s. This logic is an outright defiance of Bruin. It is a political or emotional judgment, not a historical one. The Supreme Court conference must resolve this conflict and clarify that the term militaristic is a meaningless legal standard that should have died years ago. A semi-automatic rifle, no matter its design features, is a modern, common firearm protected by the Constitution. The petitioners are asking the Supreme Court to declare, once and for all, that the AR-15 ban's Supreme Court challenge must succeed. Hand in hand with the rifle ban is the magazine ban case, specifically the ongoing saga of Duncan v. Bonta. This case challenges California's ban on magazines capable of holding more than 10 rounds. This is not a new case. It was granted, vacated, and remanded by the Supreme Court shortly after Bruin. The court told the lower courts re-examine the case using the text, history, and tradition standard. What happened? The lower courts, like the Ninth Circuit, essentially refused. They are engaged in an open, systemic act of defiance, applying a broken legal framework and attempting to use creative interpretation to uphold the bans. This pattern of defiance is an existential threat to the rule of law. When the highest court sets a clear constitutional standard and lower courts openly ignore it, the Constitution itself begins to fracture. The fact that the Duncan case is back at the Supreme Court waiting for the next Supreme Court conference shows the urgency. This is an issue of common use. Standard capacity magazines are in common use throughout America for self-defense. If the court allows the Ninth Circuit's deflection to stand, it renders the Bruin decision toothless on issues of capacity and accessories. The Duncan v. Bonta case is critical, representing the final showdown over whether the entire apparatus of state-level firearm control can be maintained by judicial resistance. The permit emergency order is a moment for celebration, but it is not a moment for complacency. The fight now shifts from the constitutional foundation to local enforcement. Lawsuits are already flooding the courts in every state with remaining subjective permit requirements. State attorneys general from pro-Second Amendment states are organizing to ensure nationwide enforcement. But the opposition is already maneuvering. We will see, and are already seeing, new bills being drafted in blue states designed to mimic permit systems under different names. They will attempt to redefine entire cities as sensitive zones, and attempt to ban carry through geography instead of paperwork. They will introduce requirements disguised as mandatory training reforms that impose massive, costly time burdens that only a few can meet. They are attempting to slow walk the implementation of freedom. The Supreme Court may have drawn a decisive constitutional line, but it is up to the citizens, to the gun rights update community, and to our vigilance to ensure that line is never crossed again. The right to bear arms is about the self-governance and self-determination of a free people. Today, that right was significantly restored. The next battle for the assault weapons ban lawsuit is what will define the future. This fight is not over. The Supreme Court has delivered a historic win on the permit issue, but the future of the AR-15 and the ability to defend your home with standard capacity magazines now depends entirely on the next order list. We will be tracking the Vermont v. Cook County and Duncan v. Bonta cases through every single conference date. You cannot rely on mainstream media to break down these complex legal issues with the clarity and dedication they deserve. If you believe in facts over fear, if you stand for the restoration of constitutional rights, and if you want real, actionable updates on the rulings that directly shape your life and freedom, then you need to be a part of this community. Hit the subscribe button right now and turn on the notification bell so you don't miss our analysis on the next Supreme Court gun case order list. We are U.S. Armed Updates, and our commitment is to break down every piece of this legal battlefield clearly, accurately, and with the constitutional seriousness this issue demands. Stay alert, stay informed, and above all, stay free.